Hello and welcome, folks, to another edition of Eye on AI. And with this offshoot of Legal View, my hope is that I can keep you up to date on information involving litigation and legal issues surrounding AI. As I've told you many times, I follow AI because I believe it is probably the most powerful force going forward for the future of human beings, for the future of our culture. And so the legal battles being fought now is going to shape a lot of that as we go forward. So I'm keeping an eye on it. And my hope is to keep you updated on all the things that are going on. Today, I want to talk to you about a really massive case going on with the New York Times versus OpenAI. Of course, that's Sam Altman's company. They do Chat GPT. And it's a huge copyright infringement. It's been going since 2023, and they're still in the discovery phase. It alleges copyright infringement, trademark dilution, unfair competition by OpenAI versus the New York Times. So what the New York Times is saying, number one, it's using millions of New York Times articles to train its large language models, ChatGPT, and they should be compensated for that. This is work done by journalists who do the hard work, the groundwork, and that work is now being taken, summarized, and provided to various people through ChatGPT and their inquiries, so they should be compensated for it. They also say that not only are they taking, or ChatGPT is taking these articles, summarizing them and passing them on, but they're actually, under certain circumstances, regurgitating actual articles in their answers to these people. And that, of course, is copyright infringement. And the big problem there is that what's happening to these media organizations like the New York Times is because ChatGPT is being used in the way that it's being used. People go to ChatGPT and ask questions, and they're sort of going into New York Times and various other media organizations, getting that information, passing it on to you. People don't go to the New York Times website. So there's no need for them to go to the New York Times website. They're getting all the summaries, everything they need through ChatGPT. And so if you're paying ChatGPT a subscription, part of that money should be going to these media organizations. Liken it to the music industry where, if a bar or a club wants to play music, they have to pay royalties to an organization that then distributes it to the artists. So they're basically saying the same thing should happen here. They're also talking about the fact that ChatGPT puts out information that's incorrect. They will pull together information from New York Times articles, attribute it to the New York Times, but it will be incorrect information. So all these things are making for a very difficult situation for them. It just dilutes their trademark and their reputation, which, as you know, in the media business is just about everything. Now, OpenAI, they have their own response. They're saying there's the fair use doctrine. They're just going and getting publicly available websites, aggregating that information, summarizing it, and passing it on. So they should be doing that. They're not substituting what they do as or for news. Of course, they're claiming that this idea they regurgitated actual articles from the New York Times. That's something that has been fabricated by the New York Times and actually engineered by their attorneys and by the tech folks that are working for their attorneys, that's actually not the case. They're also in this fight saying, look, we have to protect the privacy of the people who use ChatGPT. And I talked about this a little bit in an earlier post, a short one, where Sam Altman is advocating for an AI privilege. So what the New York Times did, they asked for over 20 million private chats with ChatGPT by users, so they could use that for evidence in the case. By using that, that would help them support some of the claims they're making about these hallucinations, or what they call AI hallucinations, where they're coming up with false information from the New York Times and also regurgitating actual line for line things from articles by the New York Times. So in order to collect that information, they need all of these chats. Well, ChatGPT is saying, look, we don't want to have to give you those things. These things are private, and he's been advocating, because it doesn't exist right now, for an AI privilege. The idea that when you go to ChatGPT and you're asking questions, they could be personal, they could be private. They should be private the same way they're private and privileged when you talk to your doctor or you talk to your lawyer. That is not discoverable information, and they're hoping that they can get some sort of carve out some exception for your chats. Now, this is an important thing for you and I because depending on how you use AI and how you use things like ChatGPT, these large language models, certainly we have some form of expectation of privacy. Currently, that doesn't exist under the law. So the question is, of course, should it exist? So that's a fight that might come out of this particular trial. There is this third party doctrine that currently exists in the law when it comes to these types of things, where is when you're sharing your information with something like ChatGPT, you're sharing it with a third party, OpenAI. And so the law looks at that and says, well, if you're sharing with a third party, then obviously you have no reasonable expectation of privacy. Well, I disagree. You have to sign these user agreements. These user agreements tell you that, in fact, you are sharing it with a third party. But again, you have to sign those agreements. You have no choice. I still think when I am sitting in my living room and I am chatting with ChatGPT, whatever that conversation is about, I believe I have an expectation of privacy. So we'll see how the courts deal with that. There was a recent Supreme Court decision involving geofencing where, and that's something used by law enforcement, where they will um, set out a blanket sort of dragnet over a particular area. Let's say a robbery occurs at a store at an area. They'll get all the information from, let's say, Google or um, other type of tech companies where they will say, okay, give me all the people in this area 30 minutes before, 30 minutes after the particular robbery that took place, and they will use that information to narrow down who might have been responsible for a robbery. Matter of fact, again, it came in front of the Supreme Court. And what the Supreme Court said was that's too much. People absolutely have an expectation of privacy when they use their phones. As a matter of fact, Judge Gorsuch, in a concurring opinion, said that he would like to see the information that you use on your phone, geolocation, how what different cell towers you use. He would like to see that become a property right, so that in order to infringe your rights to that property, the same process would have to be followed as to any other right. And so you can't just go in and ask for this information. You have to have a search warrant for it. You have to have particular facts that and specificity that allow you to look at someone's location history. You can't just generally ask for everyone in the area. If you want to look at someone's phone in that area, well, then you got to get a warrant for it. And again, it has to pass all the specifics, probable cause, specificity, all those things that a warrant requires. So the courts seem to be moving in that direction. So we'll see if something sort of comes about that is equivalent to an AI privilege. But what's important here, again, as I mentioned, is that the effect that AI is having on media institutions like the New York Times, it's cutting into their trademark by perhaps putting out information that's incorrectly attributed to the New York Times. And also, it's destroying their business model. People no longer need to go to the New York Times. They can get summaries, and which is sufficient for most people, without having to go to the New York Times website. So we'll see how that turns out. I'll keep an eye on that. I do want to tell you about a case in Germany recently. It came down, and Europe has always been a little bit ahead of the United States when it comes to regulating AI. United States has taken the position that we want to support the growth of AI. We want to be leaders in AI, so any kind of regulation is problematic in terms of that particular goal. But the EU has not taken that approach. Well, the German court, they were confronted with the problem of AI putting out incorrect information. Now, up to this point, if AI put out information that was incorrect and it caused damages, you couldn't sue them. They were protected as a third party aggregator. We're just aggregating information, is what the claim had always been and had worked in the past, saying we don't put out original stuff. So therefore, we are not liable when the information we put out is incorrect. Well, the German court said no. When you go in and get information from other people and you summarize it and you put out another document or information, that is work that is attributed to AI. to this entity known as AI. So if ChatGPT goes in, gets information, provides you with information that is incorrect, you act on that information, and it causes you damages, what the German courts have said is that you can now sue OpenAI for that misinformation. They are responsible and they are liable for providing misinformation. That is a huge step. That is not the case, or had not been the case prior to that in the EU, but now is in Germany. It is not the case in the United States. They have immunity from those type of lawsuits because they stand behind this wall that says what we put out is not original information. It's not a new thing, so we're not actually producing anything. What the German court says that's not the case. You are producing something and you are responsible for the results of those searches and the responses by your tech. So we'll see. Again, there's no case currently dealing with that, although this New York Times case could, because they're talking about manufactured information that's incorrect, according to and attributed to the New York Times, that's diluting their trademark and causing them damages. So something could come out of this case. Eventually, I would imagine it will make its way to the Supreme Court, that issue. So we just have to wait and see how all that plays out. All right, folks, I want to thank you so much for being with me for this edition of Legal Views Eye on AI. Again, I will continue to bring you more information on cases as they come up. The next one I'll be talking about involves the music industry and what they're dealing with and the cases that they're bringing against big tech companies like OpenAI and how AI is affecting the music industry. So keep an eye out for that. Again, thank you so much for watching.